Good afternoon, everyone. Today is November 18, 2025. We're going to start with our wiretap briefing, and we're going to start with NCSL, although I see, oh, they're on Zoom? Okay, so we're going to start with Heather Morton from NCSL. Heather, whenever you're ready, you can begin.
Thank you so much. I'm sure everyone can hear me okay? Perfect. And then I believe someone's going to run my slides for me. Is that correct? Oh, there they are. They're showing up now. Perfect. All right. Looks like we're ready to go there with my slides. Thank you so much. So good afternoon, and thank you, Madam Chair and members of the committee for the opportunity to speak with you today. For the record, my name is Heather Morton, and I direct the Financial Services, Technology, and Communications Program for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of the state laws regarding wiretapping, eavesdropping, and electronic surveillance and party consent provisions. Next slide. For those of you not familiar with us, NCSL is the country's most trusted bipartisan organization, serving legislators and staff for 50 years. Next slide. We serve all 50 states, commonwealths, and territories. NCSL is headquartered in Denver, where we provide comprehensive and unbiased research on state policies and legislative institutions. We also have a small office in Washington, D.C., and their work focuses on ensuring state legislatures have a strong, cohesive voice in the federal system. NCSL does not make policy recommendations, nor do we advocate certain positions to states. Instead, we provide and promote policy innovation and facilitate communication amongst states. We do this because we believe in the importance of the legislative institution and know when states are strong, our nation is strong. Next slide. So before I dive into the details of the state surveillance laws, I'll do some level setting and go over some definitions. Then I will give you the overview of the state party consent laws. And finally, I will discuss some of the exceptions to those party consent provisions in the surveillance laws. Next slide. Now that you know where I'm going with my remarks, let's get started with some level setting and definitions. First, I want to point out that I'm limiting my remarks for today's hearing to audio recordings and not including information about video recordings or location tracking. And there are a few key terms that we need to define. And the first term that I want to define is wiretapping, which involves the physical connection with a communications system at a point between the sender and the receiver and of some kind of conversation or message. This act of intercepting or recording a telephone or electronic communication is done without the party's consent. And an example of wiretapping would be if someone secretly plants software onto someone's phone to record their calls without their knowledge. The second term I want to define is eavesdropping. This can occur with or without recording. So if, for example, if someone is listening to a private conversation where they expect that conversation to be private, like if someone is standing outside your home and listening in through a window without your permission, that is considered eavesdropping. It's also considered eavesdropping if someone secretly places a recording device somewhere in proximity to that conversation, even if they weren't physically present at the time of the conversation. Eavesdropping can also include trespassing if the person who is eavesdropping or placing that recording device does not have permission to be on the premises or that property. And the third term I need to define is intercepted communications. This is a more general term that means hearing the contents of any wire, electronic, or oral communication using any electronic, mechanical, or other device. And the reason why I wanted to go over these is that states will use all three of these terms, even though they're not necessarily interchangeable. And in their statutes, states often distinguish between wire, oral, and electronic communications, and their surveillance and party consent laws may or may not apply to all three types of this communication. Wire communication sounds like it is. It occurs through a telephone, either a traditional landline or a mobile phone. An oral communication involves a person who is not a part of the conversation overhearing or eavesdropping between a conversation between two or more people that they think is a private conversation. And electronic communications can include any kind of digital conversation, except for it doesn't include wire or oral communications or tone-only paging devices. And often text messages usually fall under the term of electronic communications. Next slide. With these level setting definitions and concepts in place now, we can now turn to party consent provisions in wiretapping, eavesdropping, and electronic surveillance laws, which vary as either one-party consent or all-party consent. So one-party consent means that one person who is in the conversation must consent to the recording, and that can include the person who's doing the recording as long as they're a party to that conversation. So for example, if you're on a phone call with a colleague in a one-party consent state, you can record that call without telling the other person or obtaining their consent. And all-party consent means all parties to the conversation must consent to being recorded. So in this example, let's say you're in a group work meeting in a state where that requires all-party consent. And so before hitting record, you must inform everyone in the meeting that the meeting will be recorded and get their agreement. And as you can see on the map, most jurisdictions have a one-party consent law. We have categorized 10 states, and those are California, Florida, Illinois, Maryland, Massachusetts, Michigan, Montana, New Hampshire, Pennsylvania, Washington, and Puerto Rico as having all-party consent laws. And then in gold in the map, we've categorized Connecticut, Delaware, Nevada, and Oregon as mixed consent requirements. So we marked Connecticut and Nevada as mixed consent because they both have a statute that applies to oral recordings that authorizes one party to give consent, while both states also have another statute for wire communications where all parties must give consent. Delaware has an all-party requirement in a statute that declares it's a criminal violation of privacy to intercept a communication without the consent of all parties. This statute doesn't specifically mention electronic communications, but it does have a clause that references other means of communication. However, there is a different statute in Delaware that states that it's lawful to intercept a wire, oral, or electronic communication if a person intercepting the communication is a party to the conversation and has given consent. Oregon requires that all parties consent for oral communications and one-party consent for wire and electronic communications. I do want to note that Vermont does not have a statute addressing the unlawful interception of communications or setting any party consent requirements. In a court decision, the Vermont Supreme Court held that an individual has a heightened expectation of privacy in the home and that the warrantless recording or electronic monitoring of communications is an unlawful invasion of privacy. Next slide. So, actually, there we go. So now that I've summarized the party consent laws, let's turn to some of the exemptions and exceptions for these surveillance and party consent laws, where it is permissible to record a communication without consent. And the most common exception is for law enforcement, with 48 states and territories providing statutory exemptions. An example could be that a police department obtains a warrant or other court order to wiretap a suspect's phone during an investigation. California, Maine, Michigan, Oklahoma, Oregon and Pennsylvania specifically provide exceptions for jails and other correctional facilities. And then 46 jurisdictions also grant an exception for telecommunications operators and providers, also known as communications common carriers. And an example could be something like a telecom service provider monitoring calls to prevent fraud or monitoring calls to make sure that their system is working and functioning. 18 jurisdictions provide an exception for recording radio communications such as amateur radios. And another notable exception is for a parent or guardian who is monitoring communications with a minor child to prevent that child from potential online harms, which Alaska, Florida, and Georgia allow. Tennessee also allows an exception for a parent or guardian who installs software on a computer that the parent owns if that software is intended solely to monitor and record the use of the internet by a minor child. We did not identify any state with a specific exception for fair housing testers or for fair housing testing programs similar to what was proposed in Maryland House Bill 392 and its Senate companion earlier this year. Next slide. Finally, we did not find an exception similar to what was proposed in Maryland House Bill 314 and its Senate companion. But I did want to point out that California does have a provision that allows for a domestic violence victim who is seeking a restraining order in order to record confidential communications with the perpetrator that may be held germane as evidence for that restraining order and for it to be admissible. I've provided the full text of the statute for you on this slide if you'd like to review it later. And then next slide. So as I'm winding up my presentation for today, here are some suggestions for different ways you can connect with NCSL and our resources if you're interested in additional information that NCSL provides. And then next slide. Finally, thank you, Madam Chair, for the opportunity to provide this overview of the state laws regarding wiretapping, eavesdropping, and electronic surveillance and party consent provisions. And I'm happy to answer any questions and provide additional information if needed. I've provided my contact information on this final slide. Thank you.
Thank you, Ms. Morton. And members, I moved over here because apparently we have a system now where I can chair from any chair. So be aware, I might be sitting in your seat. No, I'm just joking. So I'm going to do it from here. I also wanted to, we're going to go ahead and have everyone speak. So if you could hold your questions, just jot them down or something, and we can ask questions at the end. Now we have our very own, and very knowledgeable Claire Rossmark, please, from Department of Legislative Services.
Thank you, Madam Chair. I am Claire Rossmark with the Department of Legislative Services. I'm also counsel to the House Judiciary Committee. And today I am going to provide a brief summary and history of Maryland's Wiretapping and Electronic Surveillance Act. Ms. Morton already addressed some of this material. I'll try not to be duplicative. The statutory provisions are found at Title 10, Subtitle 4 of the Courts and Judicial Proceedings article. The Act basically prohibits the interception and recording of any wire, oral, or electronic communication by both government and private parties. There are various exceptions to the general prohibition in our statute, situations where recording is allowed. Those include employees of telephone companies acting in the course of their employment, 911 calls, various types of law enforcement investigations as specified in the statute, intercepts of public broadcasts, law enforcement and correctional officer use of body-worn cameras, and finally, A person who is a party to a communication where all parties have given prior consent to the interception of the communication is not in violation of the act, and that is referred to as the two-party consent rule, or more accurately, all-party consent. As Ms. Morton mentioned, the wiretapping laws of most states require only one party to be aware of the recording without running afoul of the Wiretap Act. In other words, you can record your own conversation without the other party or parties knowing, and you're okay. Maryland is among a minority of states that require all parties to be aware and consent. The Act lists procedures by which law enforcement may obtain a court order from a circuit court judge authorizing wiretapping. These are very strict requirements, similar to obtaining a search warrant. The Attorney General, the state prosecutor, or a state's attorney must apply on behalf of law enforcement by submitting a written affidavit showing probable cause to believe that there is serious criminal activity going on and that wiretapping is necessary to obtain evidence of the crime. A violation of the act is a felony, punishable by imprisonment for up to 5 years and/or a fine of up to $10,000. An individual whose communication is intercepted in violation of the act may file a civil suit and recover actual damages, punitive damages, and attorney's fees. There is an exclusionary rule contained in the act which provides that no part of a communication that has been obtained in violation of the act or any evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding. The underlying objective of the Wiretap Act is to protect against intrusions into people's privacy. Under the common law, it was a misdemeanor to sit under the eaves of a house to overhear private conversations. Now, mere listening in on someone else's private conversation without doing any kind of recording is no longer a crime. But in about 1868, Maryland made it a statutory crime for telegraph company employees to divulge the contents of messages that they came across in their work. Later, the law was expanded to include telephone company employees. The associated penalty was imprisonment for up to 3 months and/or a fine of up to $500. In 1956, the first comprehensive wiretapping statute in the state was enacted, Chapter 116. It contained preamble language saying that the interception of private communications is contrary to the public policy of the state. It prohibited interception of telephonic or telegraphic communications. It contained a two-party consent exception like we have now, but interestingly, as the bill was introduced, it had a one-party consent provision, and that was amended so that it became two-party consent. The act allowed for law enforcement interception with a court order, and there was an exclusionary rule and misdemeanor penalties. In 1959, Chapter 706 expanded the scope of prohibited acts to include the use of devices other than ones commonly used in connection with telephone or telegraph lines. Subsequently, there was a series of United States Supreme Court cases that brought about some changes relating to wiretapping law. One of these cases was Katz versus United States from 1967. The court held in that case that wiretapping is a search and seizure within the context of the Fourth Amendment, and that the Fourth Amendment protects a person from unreasonable seizure of the person's conversations under circumstances in which the person has a reasonable expectation of privacy. In that case, Mr. Katz was being investigated by law enforcement. He went into a public phone booth and had a phone conversation, and the police had put a device on the outside of the phone booth that intercepted and recorded his conversation, but they didn't have a court order to do that. The court said that that is not okay because Mr. Katz had a reasonable expectation of privacy in that conversation, even though he was in a public phone booth. So holding, the case overturned the so-called trespass doctrine of Olmstead versus United States, which was a 1928 Supreme Court case. And that doctrine stated that wiretapping is not a Fourth Amendment violation because unless it involved unlawful entry into a house. Another one of these Supreme Court cases was Berger versus New York, also from 1967. That case set specific guidelines for the constitutionality of law enforcement wiretapping. These requirements included that there must be judicial authorization in the form of a court order. There must be a showing of probable cause for the initial issuance of the order, as well as any extensions of the order. There must be an application stating with particularity the specific crime that had been or was being committed and the type of conversation sought. The authority must be of limited duration. The court said that 2 months is too long. The interception must stop when the recording sought is obtained. The subject of the wiretap, meaning the person whose conversation was being recorded, must be given notice of the wiretap, or there must be a showing of exigent circumstances justifying the failure to give notice. And there must be a return of the warrant and all seized materials to the court after the fact. Shortly thereafter, the federal wiretapping statute that is in effect today was enacted in its original form. That was Title III of the Omnibus Crime Control and Safe Streets Act of 1968. That law incorporates the principles and guidelines set forth in Katz and Berger and the other Supreme Court cases, and it includes, and still does include, a one-party consent provision. In 1971, the Maryland Court of Special Appeals issued the case of State versus Siegel that was later affirmed by the Court of Appeals. In that case, the court considered Title III and found it to be constitutional in view of Supreme Court jurisprudence. The opinion stated that in order for wiretaps to be conducted by state or local law enforcement officers in Maryland, there must be a state statute authorizing that. The state statutory authority may be more restrictive but not more liberal than the federal law. And if any aspect of the state wiretap law is more liberal than Title III will govern in that regard. At that time, the state statute, it was actually 2 statutes, were more liberal than Title III in a number of ways. So the court had to look to Title III quite a bit in rendering its decision that the interceptions in question were not valid. In 1973, House Bill 962 was introduced that proposed an extensive revision of wiretapping and electronic surveillance laws. It was very similar to Title III, and it passed the House and the Senate, but it was vetoed by Governor Marvin Mandel because of the one-party consent provision that it contained. His veto message was very strongly worded and included statements that the implications of the bill are frightening and that he refused to, quote unquote, be a party to making such unlicensed intrusions on private communications a matter of state policy. So that bill did not take effect. In 1975, an investigating committee was established by the General Assembly to look into allegations that the state police were conducting illegal surveillance of citizens. One of the conclusions of that committee was that our current wiretapping laws were inadequate, and they recommended that a comprehensive state law be passed patterned after federal law. So that's what happened in 1977. Chapter 692 was enacted. That's the original version of our current law. It's based heavily on Title III, but it is somewhat more restrictive, most notably with regard to the two-party consent requirement. Over the years, the law has been tweaked to keep pace with technology and adapt to changing needs. In 2025, a number of bills were introduced seeking to amend the Wiretap Act. They're listed on the slide. None of these bills passed, although the substance of Senate Bill 1046 was amended onto Chapter 609, the Davis-Martinez Act, and that provision authorized the use of body-worn cameras for correctional officers. Just to briefly summarize the other bills, House Bill 130, Senate Bill 38, and House Bill 706 sought to reclassify a violation of the Wiretap Act from a felony to a misdemeanor. Senate Bill 61 sought to establish two new exceptions to the act by making it lawful for a person to use a cell phone to record a communication in public if the speaker should reasonably anticipate that the communication could be overheard or intercepted, and two, by making it lawful for a person to use a security camera on real property. Senate Bill 1007 and House Bill 314 would have authorized a court to receive into evidence an intercepted communication if the case involves the commission of a crime and certain other requirements are met. Senate Bill 107 and House Bill 392 would have authorized a person to intercept an oral communication if they are working as a fair housing tester. House Bill 748 would have authorized the use of body-worn cameras by municipal enforcement officers. And House Bill 1409 would have authorized the electronic monitoring of a resident of a medical care facility if certain requirements are met. And that concludes my presentation.
Thank you very much, Claire. I appreciate that. And since none of you look like David Gray, I'm assuming that Mr. Gray is is virtual. So we'll have Mr. David Gray from the University of Maryland Carey Law School.
Thank you very much for allowing me to attend remotely. The semester kind of got away from me. Can I be heard and seen?
Yes, you're fine. Thank
Great.
you.
Thank you very much. And thank you very much to Ms. Morton for her presentation. Very helpful, and will allow me to be shorter than I was otherwise going to be. So you are confronted with what is fundamentally a political question. And to my way of thinking, that means that you have to ask questions about the public ethics for the people of Maryland, and also engage in normal cost-benefit analyses that legislators always have to engage in. And so I'd like to address those two big questions that are presented to the committee. First, the question, one of the fundamental political questions that you have to ask is, what kind of people do we want to be as Marylanders? And in particular, what kinds of rights and liberties do we want to recognize and protect? And the fundamental question that's presented to you is, do you want to recognize a fundamental right for citizens of Maryland to consent to the interception and recording of their oral communications? Or alternatively, do you want to provide a fundamental right to anybody who happens to be a participant in a conversation to record those oral conversations or to record those wire transmissions? And so it really is a question of who is in the first seat as to the right. Are we going to be a state where there is a right to consent, or are we going to be a state where there is a right to record? At present, as a two-party consent state, we recognize a right to consent. And that is related to the second question, which is what kind of society do we want to live in? The answer to that first question of rights influences the way that we live our day-to-day lives. And so do we want to live in a society where we always have to wonder whether we're being surreptitiously recorded? Do we want to have to worry about whether those surreptitious recordings might be shared or published or used? And do we want to have to worry about the long time, perhaps forever, effects on our abilities to function in society where those, depending on how those recordings are used? And that is not an abstract question. We all carry around with us now eavesdropping devices and recording devices, which gives each of us the capacity to record everything around us all the time, including our communications. And so the fundamental question that's presented to you as legislators is, do we value communicative privacy? And if we do, how are we going to protect it? We have a lot of suggestions in our public culture and in our legal culture now that we do value communicative privacy. Some were just talked about. So our constitutional culture around reasonable expectations of privacy recognizes a right not to be recorded without judicial approval by law enforcement officers in our telephone conversations, or, and that's the Katz case, or in the Berger case, to have eavesdropping devices installed in our homes or our offices. Why do we have those rights? Well, the court has told us because they don't want to grant law enforcement unfettered discretion to record. They want the government to intercept and record our oral and wire communications only when there are good and compelling reasons to do so. And we put judges in the driver's seat to balance those competing interests. But fundamentally, what's recognized is a value in communicative privacy that is a given in the court's Fourth Amendment jurisprudence. We also recognize the value of communicative privacy in a range of evidentiary privileges: the marital privilege, the clergy penitent privilege, the patient psychotherapist privilege, the attorney-client privilege. All of these privileges, some in rules, some as a matter of common law, are organized around the proposition that there are certain relationships of trust that play a crucial role in society and provide us with transcendent goods as individuals and as a body politic that would be threatened if we didn't preserve communicative privacy in those relationships. We also have a number of deliberation protections. Grand jury secrecy is one. The prohibition on the admissibility of juror testimony is another one. And again, these are legal rules that recognize the fundamental importance of some degree of communicative privacy, but here in the important enterprises of intersubjective exchanges of reasons around the process of discursive truth-seeking. We don't think that grand juries can come to reasonable, reliable conclusions if their processes are public or if their deliberations are recorded and reported. Similarly, we don't think that juries can conduct deliberations, can seek truth in a reliable way if their deliberations are recorded and reported. We think that the communicative privacy affects the quality of that deliberation, affects the quality, affects the ability, the capacity of those bodies to engage in truth-seeking. These are just some specific examples in existing federal and Maryland law where we recognize the value of communicative privacy and the critical role that it plays in specific areas of our society. But those specific instances of that principle have broader application. And that is what's reflected in Maryland's preservation of the two-party consent rule. In Maryland, at least as of now, we recognize that some degree of communicative privacy plays not just a specialized role in a few areas of society, but plays a more general role in the quality of our civil society and our interpersonal relationships as Marylanders. And as we think about those, as we think about what would be given away if we were to convert in whole or in part to a one-party a one-party consent state, it's important to consider the costs of that kind of decision. A few costs for your consideration. First, the effects of being a one-party consent state on ethical self-development and pursuit of the truth. It's well documented in the social sciences through the Hawthorne effect, which essentially recognizes that people who are subject to sociological, psychological studies, that their performance is affected by their knowledge that they're being observed by studiers, or more general demonstrations of observer effects show that we are affected in our pursuit of ourselves and our exploration of ourselves and our pursuits of truth if we are being observed. A couple of interesting studies to support that. In the summer right after the Snowden revelation, a group of scholars did a study of Google searches, and they compared Google search terms from before and after the Snowden revelations and found that there was a dramatic reduction in searches that could be considered sensitive. So people doing searches for potential psychiatric or psychological disorders and so forth, things that they now were concerned could be visible to the government or others. They tamped down on their pursuit of knowledge and their pursuit of their curiosity. Similarly, there are numerous studies documenting that when people simply have the possibility that they might be viewed, something as simple as an animated eyeball in the corner of their computer screen, that affects their internet usage, again, tamps down on their exploration of sensitive topics that might be important to them, but they feel that they are constrained by that threat of being observed. And that idea of communicative privacy is recognized going back at least to the Greeks. Aristotle talks about the importance of the private sphere as an area for self-development that allows each of us to go out into our public projects, and that the quality of our democratic society is deleteriously affected if we don't have the benefit of that protected private sphere. And that is what is at stake in going to a one-party consent system. There also is the very real fact that not only can we record each other, but we live in a world now where immediately, without a moment's thought, somebody can put those recordings on social media or other places where they are lodged forever, and those could have permanent consequences on reputation. And knowing that somebody very well could be recording us and that recording could appear on TikTok at any moment necessarily has an effect on our willingness to be open and honest and explore ideas with each other. And so just think about it. Do a few mind experiments for yourself. Would you conduct yourself differently if you were at a dinner conversation with your family versus a panel discussion at a public event? Would you conduct yourself differently if you were talking to a friend versus talking to a reporter? Would you conduct yourself differently if you're talking to a reporter on the record versus off the record? And I think that intuitively our answers to all three of those questions is absolutely yes. And that reflects the value and the importance of communicative privacy. We need to have the ability to engage in both of those kinds of communicative environments. And the only way that we can secure that to ourselves is to preserve the right of that is implied in two-party consent. And just one last study on this point. Elizabeth Dunn and other researchers recently documented that just having our phones visible on the table while we're having conversations dramatically reduces the quality and the depth of those conversations. The reasons for that outcome are complicated and unclear, but certainly some of it would have to do with the fact that we are potentially could potentially be recorded. So those are the costs of converting to a one-party consent society. But of course, there are costs that come with being a two-party consent society. And one of those is addressed by House Bill 315. which I am here in support of. There is a distinction in constitutional law between rights and remedies, and an important distinction along that line in the Fourth Amendment context is around the exclusionary rule. The exclusionary rule in the Fourth Amendment context has been enforced by the Supreme Court as a means of deterring law enforcement conduct, and therefore doesn't apply in circumstances where an individual conducts a search for their own reasons, a trespass or anything else, and they find evidence of a crime and they present it to law enforcement officers. As long as that person wasn't acting as a state agent, the exclusionary rule doesn't apply. As I read the proposed rule, it simply replicates that distinction in the context of Maryland law, which makes good sense to me. If law enforcement officers, through no fault of their own, have a recording that is crucial evidence in a criminal prosecution, they should certainly be able to do it. And we don't need to give up the right in order to provide them with access to that evidence. We can preserve the right, but simply modify the remedy. Many of the other costs that might come with a two-party consent rule have already been addressed in the law. There are exceptions, as was noted, for law enforcement officers wearing body mics or law enforcement officers using body cameras, and there are numerous other well thought out exceptions in the existing law. And that's, to me, signals that we are in a state where we have the rights, that we have made these ethical decisions about the kind of society we want to live in, where we want what rights we want to recognize. And there's nothing compelling that I've seen so far that would suggest to me that we ought to shift. The only reason you might have is that we are among I counted up as 16 states who have one form or another of two-party consent, either with respect to interception of telephonic communications or personal oral communications. So we are in a minority, but we are in a noble minority that has made a decision about what kind of society we want for Marylanders. And I don't think that there's any reason that we should cow to the majority, particularly when we have such good friends. Thank you very much for your time, and I look forward to the conversation after the other presenters.
Great. Thank you, Professor Gray. Actually, we are going to take questions now for either, if anyone has any questions for Ms. Morton from NCSL, from Claire Rossmark, or from David Gray, please let us know. Okay. Delegate Cardin.
Thank you, Madam Chair, and it's great to be back in our seats. You didn't take the throne. I have a couple questions. One for Ms. Morton. Are there states that are trying to chip away at the two-party consent using different lots of bills, kind of like Maryland did, where they're trying to chip away using for different purposes and different reasons? For example, with hearing officers, or with state's attorneys, or with victims of domestic violence. Each one is chipping away a little bit more. Do you want me to do all my questions at once, or do that? Because that's the only one for Ms. Morton.
Just direct that one to Ms. Morton, and then you said you have another. How many questions do you have?
I have three others.
Okay.
One for Mr. Gray and two for Claire.
Yeah, let's let Ms. Morton answer that question, please.
All right. Thank you, Madam Chair. Thank you, Delegate. There are absolutely, every year there are bills that are introduced that would change up the party consent as well as the exemptions. But we can, after the hearing, if you like, what we can do is we can send you a list of the 2025 legislation so that you can see the full picture of that legislation.
Great, thank you. Professor Gray, artificial intelligence. Have you done any work or any research on how that and the ability to actually not just record, but to maybe alter communications could be another reason why we want to make sure that there are legal remedies that people are afforded if they are being recorded without or unknowingly being recorded?
I'll take that softball and hopefully at least get a line drive single. Yes. And so I'll take it one step further and imagine that somebody has produced a deep fake of me where I seem to be making statements in like a Project Veritas kind of sting environment that I didn't make and are shameful and are put out on the internet. If I have to worry about trying to prove that they're false. And if I live in a one-party consent state, and that's all I've got. If I live in a two-party consent state, then I have two causes of action, right? And two paths to pursue. One is that this is not me. And second, to the extent that you present it as a recording of me, you violated Maryland law. And so it's another layer of deterrence against that kind of activity. And I think that example of Project Veritas is important to keep in mind in light of the question that you just asked, Ms. Martin. And so I'm not nearly as up to date on the details of the individual states, but there were two instances of state laws being challenged within the last 15 years. One was just last year, which was a case in Oregon, I believe, Ms. Morton, if that's right, it's either Oregon or Washington, where Project Veritas was challenging the constitutionality of a two-party consent law, and on a 10-2 vote, an en banc panel, the en banc Ninth Circuit upheld the two-party consent law as against Project Veritas. And so our law protects us against that kind of gotcha, out of context journalism. And I think that's a good thing. And the other example was in 2014, an Illinois law construed the existing Illinois statute at that time as a one-party consent law, and the legislature turned right around and amended the law to make clear its desire to remain a one-party consent law. And so while many of these states might be creating exceptions, they have stayed committed to that fundamental right to consent to the interception and recording of oral and wire communications. And I think that's a good thing.
Thank you. And the two questions for Claire are, one, you may pass the one to Professor Gray, but the other one, House Bill 748 that you discussed, allowing law enforcement officers to be able to use body cameras, but that would not, they're still required to let, if it had passed, it would still require them to let people know they're being recorded, wouldn't it? So they would still be required to make sure that there's two-party, at least knowledge, if not consent. That was question number one. And question number two, I mean, you don't have to answer it now if you're not sure, but question number two was in CATS that you discussed, unless, if it's only a one-party consent state, are you telling me that somebody can say, you can be in a private conversation with somebody, but the Supreme Court is saying that I can tell them it's not being recorded and still, and still record them? In other words, I can say to somebody, somebody can say to me on the phone, this is a private conversation, don't worry, it's only between us, but then record me because it's a one-party consent state. Is that okay via CAT?
You know what? I do not know about if somebody tells a lie like that. I just know that if I'm having a meeting in my office, let's say I tell you to come into my office and we're having a meeting, and I record it, it's a one-party consent state, and I record it, and you don't ask me if it's being recorded, that is not
Right. But should it make a difference?
That's okay, but I don't,
Right,
I honestly don't know about whether it's okay if I tell you
Should I make a
it's not.
difference if I bring you into my office and say this is just between us, but it's a one-party consent state, so can I record or can't I? Anyway, thank you.
I don't know the answer to that offhand. I don't know if Professor Gray probably does.
The answer to that question from a constitutional point of view is absolutely. There's no constitutional violation there. The court, as early as on Lee, has been very clear that that we trust who we trust, and if those people violate our trust, then that's not a violation of the Constitution. And that's true even if the person is acting as a law enforcement officer. And so the only thing that would prevent the kind of conduct you just described, Mr. Garden, is if you have a statute that prevents that kind of activity. And then with respect to notice and its relation to consent, some states, Pennsylvania is an example, specifically allow for notice and then continued participation in the conversation to serve as consent. Other states are less clear about whether notice itself is sufficient to ground consent.
So what I'm hearing is that we should probably put in a no-lie statute. Okay, let's go on to Delegate Grammer, and then I have a few questions as well.
Thank you, Madam Chair. I have a question for Professor Gray. Thanks for being here today. So I'm going to speak as one of the sponsors of the legislation in question. I was the sponsor of House Bill 314 last year. But I'm also coming at this as a Fourth Amendment guy. That's what got me into politics way back before my hair was gray. When this issue first came to us, the story that we were given was by an advocate who served elder folks who were abused, was in some kind of care situation where they lived independently under the care of a caregiver that was not a family member, and family would visit and find evidence of abuse. Multiple types of abuse, but the one that was presented in most cases was physical abuse. And they would say, we don't know what's happening. They would put up some kind of camera. They would find actual physical abuse of an elderly person. A lot of these cases, they had cognitive issues and the victim couldn't communicate, so they had to rely on recording. But of course, with our current statute, we could not admit that, they could not admit that evidence in those situations. The subsequent stories that we were brought were related to sexual abuse. And what we found was in most cases, a victim, not only was it the most probative piece of evidence they could deliver, it was frequently the only piece of evidence that they could deliver was some kind of recording. So I just want you to kind of understand, you know, for me, being able to admit objective truths for people who are actual victims is important. And I feel we can have a balance between not changing consent and not changing, as you said, the way our expectations, the way we live, while achieving a way for these people to find justice. So I want to actually present you an analogy. So we can kind of compare this to another scope of law. Let's say we have a drug dealer, cocaine buyer. We want to prosecute the dealer, but you know, in many places, and including this state, there's a big interest in not prosecuting people who are in possession. Can we or can we not, even though it is an offense to possess cocaine, and that is a material fact in a case, can we prosecute a dealer and still not prosecute a person in possession, even though they objectively are in possession?
I'm sorry, Mr. Grammer, I lost you at the very last two sentences.
Sure. So you have a dealer. He is objectively dealing. You have a consumer. He is objectively in possession. Can we or can we not prosecute the dealer and still not prosecute the buyer?
Oh, yes, absolutely. Absolutely. And I do, I just one point of personal privilege. It's hard for me to be too, to worry about your complaints about having gray hair too much. I'd give anything to have some gray hair.
It's a good look. Stick with it, brother.
But I do also want to be clear that that I am in favor of either abandoning or significantly relaxing the exclusionary rule that exists in the law now. I think that we can untether the right from the remedy. And so before I looked at the law, what I had independently thought was that you could abandon the exclusionary rule in prosecutions for any of the enumerated crimes under this existing statute, or abandon it altogether and just have the existing criminal and civil enforcement mechanisms, knowing that they are very unlikely to be utilized by somebody who's being prosecuted for elder abuse or prosecuted for a sex offense.
Okay, well, you've got a single. Let me pitch you a softball and you can have a grand slam here. My other half of the analogy is this. Can't we change the rules about admissibility without striking at consent and the right of consent and the expectations of consent and the way we live regarding consent? Can we change the rules of admissibility without getting into like enforcement and prosecution of people, recording? Can't we actually get at the rules of admissibility so we can see justice was served for these people who are suffering from egregious cases without blowing up the whole system?
Absolutely. And again, there is a distinction between rights and remedies. And the sole justification for the exclusionary rule in the Fourth Amendment context is to deter law enforcement officers from unlawful recording or wiretapping or unlawful searches and seizures more generally. And here we are talking about private actors, and I have a very difficult time seeing how an exclusionary rule in a criminal trial is going to deter somebody like Project Veritas from surreptitiously recording me. The one exception that I think is that was in the bill that was presented last year is where the private party isn't truly a private party, but are acting under the direction of law enforcement officers. And there, the idea would be to deter law enforcement officers from persuading a private party to do something they can't do lawfully on their own. And that part of the bill seemed to me to reflect exactly the Supreme Court's justification for the exclusionary rule, and to my mind, the only justification for an exclusionary rule in criminal trials more generally. So I hope that at least got me a triple.
Thanks for your participation.
Thank you very much for having me.
Thank you. Delegate Conaway.
Recognizing me. Mr. Gray, I would like to ask this question. So under House Bill 748, traffic enforcement could record a conversation and not notify the person that they're talking to that they're recording. Is that correct?
I will trust you on that interpretation of the law. If that's
I'm looking at the bill and it says including. So I'm leading to something else, because then you have Wacomico County is starting to use body cameras or want to use body cameras to help draft police reports. That means that they could be recording before they notify you or Mirandize you or something like that, let you know that they're recording, because it's saying right here the AI is going to draft up basically what was going on and what was said before you know that you're having this kind of contact. Is that correct?
So I think that there are at least two separate questions. So the first one is, do you want to have an exception for body cameras? And that is fundamentally a policy question. There's no doubt that having a notorious body camera that is recording somebody in their interaction with a law enforcement officer means that they're not consenting to that recording. But the benefit that you get is the monitoring of law enforcement behavior. And so okay, I recognize the cost, but I also recognize the benefit, and that's why we elect you. Secondly,
one at a time. Can you go one at a time?
Sure.
Because what about the traffic enforcement people?
And so
they're recording you and not letting you know.
And so what's the recording device there? Is that the camera on the patrol car? Where's the camera there?
Well, we're talking pretty much body-worn cameras,
right.
I thought.
Yeah.
Go ahead.
So assuming that it's notorious, and so it's right there strapped on their chest, that is, again, a policy question that you guys have got to wrestle with. I can see the costs and benefits on both sides, and it is not an easy decision. And I trust your wisdom in making that decision. Secondly, your concern about Miranda rights and interrogation, that, to my way of thinking, is another potential benefit of having the body-worn camera. because then we know whether or not there was an interrogation. We know whether or not sufficient Miranda warnings were given, and we know what kind of interrogation methods were used and whether they might be the kinds of methods that would produce an involuntary confession. And so from the point of view of protecting both Fifth Amendment rights under Miranda and due process rights under the Fifth and the 14th Amendment, the body-worn cameras are a benefit to society and to criminal defendants. Again, there are costs in terms of communicative privacy. I'm not taking a fulsome position on body cameras, but I do recognize that you could have that exception while still preserving the core right.
Well, I certainly appreciate you acknowledging the benefits of the body-worn cameras, because you know that's my bill. But anyway, so, well, okay. If in Maryland a person records their own conversation with another person, and this is a two-party consent, but they don't tell the other person, and they don't share it with anyone, are they in violation of the law?
They are, absolutely.
You didn't mention that when you mentioned the two scenarios, but that's another scenario.
Yeah.
So they are potentially in violation.
If they absolutely, and even if it just rests on their phone, under Maryland law, they have violated my right to consent to that recording.
Yes. I would agree with you 100%. What about creditors that call into Maryland and talk to you and notify you that this is being recorded on a recorded line, but you didn't consent? You didn't say, they didn't ask you for your permission. They tell you and they notify you that this is being recorded this is going to be recorded on a recorded line. Is that legal, in your opinion?
And so the question there is notice and then participation. Does that constitute consent? My
Yes.
own view is that it turns entirely on whether somebody could reasonably terminate that conversation. So I'll give you a different, more benign example. I generally don't record my classes because we live in a two-party consent state, and I cold call on students. And I don't think that if I'm cold calling that they are consenting to the interception of their oral communications. But then there are days, for religious holidays, snow days, for example, when the deans ask us to record as an accommodation to students who can't come in. On those recording days, I tell students we're being recorded. I tell them I'm not going to cold call because they can't consent to the cold call, but that if they choose to participate in class, then by virtue of that participation, they will have consented to the interception of their oral communications. But when I respond to them, I won't use their name so that they are relatively anonymized as best they can be. And so that's the way I kind of navigate that idea of voluntary participation, notice, and consent, but it's a thorny area of the law. And as I said a moment ago, some states explicitly say notice plus participation establishes consent. Other states are a little more muddy about it. My own view is that we should respect people's right to say no to the greatest extent we can, and being in a two-party consent state at least enforces that ethic. If it isn't always honored completely in individual circumstances.
Right. So in my example, I asked if let's say if a creditor calls you and notifies you that you're being recorded,
Yeah.
and you haven't given consent. If they say, is this Frank Conaway? And I say, well, I need to let you know this is a recorded line. Is this Frank Conaway? And I say, yes. Does that mean I've consented to be recorded because I answered that it is me?
I think that the only thing that we could do in that circumstance is to hang up the phone because we're not going to consent, or maybe alternatively say, I don't consent to the recording of this call. And so turn off the recording. And if they don't do it, then turn off the call. But that is muddy waters. And so if you wanted to amend the law such that it said affirmative consent is required, and that in a sort of quasi-contract way that compelling somebody to consent is not real consent, I would be all on board with that. And if you want to limit the capacity of people from out of state to force people to give up their their rights under Maryland law to refuse consent, then I think that would be an admirable addition to the law as well.
Thank you so very much. Well, Ms. Claire, can I ask Ms. Claire a question?
Sure.
Thank you, Ms. Claire. Ms. Claire, what is the exclusionary rule that you spoke about?
Where is it?
No, what is it? Can you briefly?
It basically says that if the Wiretap Act is violated, then that recording is not admissible in any court proceeding.
But if, okay, so that's the exclusion right there. All right, thank you. And one question for Ms. Moore. Is she still here? Oh,
Yes,
okay,
I am.
can see that. I'm sorry, I had to. You first said in your first example, number 1, that you had to have a hardwire connection. Is that correct?
Thank you, Madam Chair. Thank you, Delegate Conaway. Are you talking about when I was defining wiretapping?
Yes, the 3. What was the third one you said? The second one. Go ahead.
Yeah, so the first definition was the wiretapping, and that's like the physical, like somebody's actually going into the communication system and creating, they're doing something where they're recording it, that kind of so they're actually interacting with the communication system itself. The second one was the eavesdropping, where you're listening in on someone else's conversation. And then the third one is the more general intercepted communication, which can be, can incorporate and encompass both of those, or just be a little bit more general.
Okay, so in the first example, it doesn't have to really be a hard wire. It could be on wireless communication, right? Is that
Right.
correct?
So it could be something like a like somebody puts like some kind of download an app or something onto like if it's on your mobile phone, they could download an app that could be used to record your conversation. Or it could be something, much more technical that is a little bit beyond me, where like the, law enforcement will actually put like a pin and trace. So, something like that, right? So it's something where they're actually getting into the communication system to record it somehow.
All right. Thank you so very much.
Thank you.
Chair.
You are welcome. We're going to now go to Delegate Phillips and then circle back around to Delegate Simpson. And I had questions, but we'll see. You all might ask them. Some of them you have. Thank you. Delegate Phillips.
Thank you, Madam Chair. For those of us who are generally supportive of the idea of an all-party consent, guess I'm telegraphing, as we look at some of the issues that have come up, should we focus on expanding, and this is probably for Professor Gray, this is an opinion question, should we focus on expanding the exceptions, and what criteria should we use if we consider expanding, i.e. for the enforcement individual who is dealing with code enforcement, and perhaps they now have a body-worn camera, or for incidents where a person has been abused and they have recorded it. There have been a number of exceptions, the housing piece. So should we focus on that? And if so, give us some thoughts about the criteria that we might consider if that's the way we go.
Thank you very much for the question. And so in your examples, I see 2 compelling government interests. One is access to the best evidence in criminal prosecutions, and that's the exclusionary rule bill. And I don't regard that as an exception to the right, that we can hold fast on the right and then adjust the remedies. Of course, there's no such thing as a right without a remedy. But if the goal is to deter law enforcement agencies from violating the Maryland prohibition on wiretapping and interception of oral communications, contrary to the statute, then we don't need to enforce an exclusionary rule against recordings made by private individuals. And so we can,
But I'm taking this out of the context of law enforcement.
right, yeah, and so
Housing code enforcement.
and so then the next is, do we have true exceptions to the law where we don't require all party consent? And that is one of those fundamental policy questions. I think the framework that I would use is there a compelling government interest at stake that can only be served by creating an exception to the general prohibition on one-party consent? And that's in the context of housing enforcement, maybe. I confess that I know very little about the process of housing enforcement and how being able to record would advance that compelling governmental interest. But that would be the framework that I would use, is to identify that compelling government interest and then narrowly tailor any exception that was going to be made in order to accommodate that interest and no more.
In other states, as we look at the history behind the many states that are one-party consent, does this issue come up, or are we seeing the use of one-party consent in all types of scenarios: code enforcement, fair housing discrimination, sexual abuse, evidence thereof? Any comment from NCSL?
Thank you, Madam Chair. Thank you, Delegate. I don't have specific information in response to that, but I would say that in terms of a private individual rather than law enforcement, so I'll distinguish from law enforcement because, of course, they encounter you run into the Fourth Amendment and the search and seizure and all that. But I believe that, if someone is, if they decide to record a conversation, that then they can, it can be brought in to a, into a court case if there is a civil case or potentially a criminal case. But of course, it is possible, that the defense, of course, has the opportunity to challenge that in terms of if they want to file like a motion to suppress, and they can make the successful argument, then they can, they can suppress that evidence and it might not make its way into the hearing or into the evidence of that hearing. But certainly, yes, the plaintiff or whatever who is trying to use that evidence can certainly try to bring it into the court.
We also have a challenge, I guess, just with the speed of technology. And so I want to ask this question because, Maryland, we're a little funny, right? We don't require consent for video, but we do require consent for audio. Does that make sense?
Professor Gray.
Professor Gray. Yes.
Oh, sorry. And so my understanding of the history of the law is that it was adopted at a time where video recording was relatively unavailable. And so it just wasn't on the minds of the legislature at the time. And so it is a loophole. And so I'm going back to the question that Mr. Grammer asked me, Delegate Grammer asked a few minutes ago, the nanny cam of the elder abuse, the video part's admissible, doesn't violate the law, but the audio part does. And that does strike me as an artifact of the time at which the bill was written. It would be a worthy exercise to think for the legislature for you guys to think about whether to include video surveillance in that list among the two-party consent, all-party consent requirements. It does start to get sticky though for things like, I don't know, Ring doorbells now, right?
Right.
Those are out and about. And so you're right to recognize that technology might have overtaken us, and trying to write that law now in our current technological environment, I would not envy you or your staffers.
But thank you. And I'm going to make this my last question. In light of states with two-party consent, states with one party or all party, what are the thoughts about the types of litigation in one versus the other? What would we see differently if we had a one-party consent, and what is prevalent in a one-party consent versus a two-party consent, and vice versa? Does that make sense? Professor Gray, I think you started.
Yeah, so I'll say something that would disappear. So I recently had a conversation with a principal in the public prosecutor's office, and this is the office of the Attorney General that's dedicated to prosecuting public corruption. And from them, I understand that that office routinely uses this law to prosecute participants in public corruption because they make these unlawful recordings. And so we would be taking a tool from the toolbox of at least one very important prosecuting office in the state if you were to convert to a one-party consent law.
Are there things that are prevalent in the one-party consent law because people are upset that you've taped me and you didn't tell me? My sense is there's probably quite a bit of litigation around that. Anybody have any information on that? I don't know.
Maybe Ms. Morton, do you have any research on that?
Thank you, Madam Chair. Thank you, Delegate Phillips. Unfortunately, that is not any research that I prepared for today. We can certainly see what we can find and get back to you and follow up with you after the hearing.
Thank you.
Great. That sounds good. Thank you very much. We're going to circle back around to Delegate Simpson, please.
So it sounds like to me what I'm hearing is that it's kind of a four-prong, right? So we have admissibility as one issue, whether or not, if I've recorded something, it's a crime or whatever, is it admissible in court? That's one issue. The other issue is who can do this, right? We've already talked about law enforcement, what they're able to do, or what private citizens, or as my seatmate, that we talk about is vulnerable individuals, right? We hear schools who want to, or other places in which you have individuals who are vulnerable, and how do we prove anything has happened to them, right? So it's who, it's whether or not it's admissible, it's whether or not you have the consent of the other individual. And I don't think that anybody here in Maryland seems to be very strong on wanting a two-party consent. But then there's also the issue of what is the penalty? And where I'm going there is just, in my bill of like making it a misdemeanor, and I don't think it solves everything, is, do we really want a law that has so many exceptions to the rule? Is somebody, when it comes to housing, is that worse than rape or assault or something else? And like, what are we going to consider are the exceptions so that we can protect vulnerable individuals? And right, I mean, we're trying to, is there, so NCSL, is there, did I cover all the four right? And whether it's admissible, who is it that can make these recordings? What is the penalty for these recordings? And then of course it's whether or not this is two-party or one-party. And I guess there's two questions here. One is, if I've got a recording, because we have 10-year-old, 12-year-old kids who've made a recording of something terrible that has happened to them. They go to the police, and we have seen, or even other individuals, family members who made a recording because they thought something wasn't right, and now the police are telling them, you've committed a crime, right? So I guess another is there any immunity for someone who is just literally trying to protect themselves, where they are ending up in more trouble than the individual who's caused the harm, right? We know there's drugging and rape and all this other kind of stuff. So is there a state still has two-party consent doesn't have this huge laundry list of all the exceptions, but does consider vulnerable individuals or, crimes that most of us would agree are horrifying, and a reasonable penalty, because I have a hard time thinking that it should be a felony, so we should be equivalent to rape or murder for recording someone, especially when most states have a one-party. What is that reasonable penalty for recording, especially if you're, like most, don't know, what that penalty would be. Most people are not thinking of what the penalty is when they commit a crime. They have no clue how large our books are and what they are. No one is thinking that.
Okay, so we're going to let Ms. Morton, are you going to answer that?
Thank you, Madam Chair.
Thank
Thank
you.
you, Delegate Simpson. That is something I didn't prepare for today, but I can certainly pull together the information about what the penalties are for and to make sure that I understand correctly what you're asking, is the penalty that's applied to the person who records something in violation of the statute, correct?
Correct.
Okay, yeah. So I'm certainly happy to pull that together, and I can send that to you after the hearing. So
And
that
another
so you
question-
can compare whether it's a felony versus if it's a misdemeanor, and what maybe if we can identify what the actual penalties are. So if it's like if they have to pay a fine, or if there's
Or
jail time.
exceptions, or what the exceptions would be, so that Maryland doesn't have this huge long list of, this year we're going to bring in, for housing, and next year, it's going to be for, is this only in these vulnerable situations, and what isn't a vulnerable situation? When can we use it? If I have a video and it's got sound, is it admissible for just the video part and I take the sound out? Or if it's already together, I don't know the answer to that.
Okay. Certainly. Thank you, Madam Chair, and thank you, Delegate Simpson. So we can certainly pull together some resources and share that with you after the hearing, and see if that will answer your question. And certainly if not, then we can continue to work with you.
All right, thank you.
Great.
Thank you.
Thank you. Okay, and for one last question, we're going to end our round of questions with Delegate Conaway.
Thank you, Chair. Mr. Gray, this is for you. And first of all, let's all be mindful of the reflection from your glasses of what you're looking at on your computers. So in reference to glasses and spyware, if a person has on a set of recording glasses and they're walking around in public, but they're engaging in private conversations with people that don't know that they have on the spyware, could that potentially be a violation of the two-party consent?
With respect to the audio recording, yes.
Yes. Oh, I know. Thank you. Oh, thank you. Thank you, Chair. Thank you, Mr. Gray.
Okay, that was an easy question. Nice softball. Thank you, Delegate Conaway. Okay, let's keep going. We're out of practice, but we are happy to see each other. I'm glad that everyone is here. We're a little out of practice, so this is what we're going to do. We're going to move to Baltimore City Office of the Public Defender. We're also going to hear from Frederick State's Attorney, and we're going to ask as questions after they are finished, and because we know how to get in touch with everybody here. And if you don't, we'll make sure we make that information available to you. So Ms. Marguerite Leno, you are up, and you're from the Baltimore City Office of the Public Defender. Thank you.
Madam Chair, so I think we have a slide. I'll just wait for it to come up. And I'm going to try to keep my comments a little bit more grounded in some of the questions and some of the direction of where this is going, as opposed to just sticking to the slides, because I think some of this may have been covered already by the previous presenters. And so why does OPD, the Office of the Public Defender, support two-party consent? Next slide, please. For one, the two-party consent provision, it guarantees greater privacy protection than available under federal law, and that was done intentionally by this state. So for in addition to that, it protects from fabricated evidence. With AI and audio manipulation becoming increasingly sophisticated, two-party consent law helps prevent malicious actors from creating or editing recordings to frame individuals. So one of the questions that was just posed that I believe it was Delegate Phillips, who stepped out for a moment, one of the things that he said is, what would we see differently in thinking about where there was no two-party consent and we had one-party consent? I can share with you that from our perspective, one thing we would see differently is that one-party consent would have the unintended consequence of encouraging some vigilante self-help. What do I mean by that? Is that you will have individuals now, for example, there was a case in where there was a child who was a victim of a sexual assault. The child reports the incident to her grandmother, and this case is the Cloyd Holmes v. State case. The child reports the incident to her grandmother and to two of her great aunts. The child relays the incident consistently to all of the parties she shares this with. When the mom confronts the child to ask about why haven't you shared this with me, or why did you go to your grandmother first? And for context, the alleged or the convicted sexual assaulter was the boyfriend of the mother, so not the child's other biological parent. In that conversation, at some point, the mom suggests that the child recants and says that she dreamt this and this did not happen. The mom then makes efforts to record her child in this statement to present that in the defense of her boyfriend. Based upon the current law, that evidence was excluded and not permitted to be used against the child. If we were to move to a place of one-party consent, an unintended consequences, that evidence would be used against the child. And so we're thinking about protecting vulnerable individuals. We should also be grounded in the idea that two-party consent can protect vulnerable individuals. In addition to that, next slide, please. We are in support of two-party consent because it prevents coerced or manipulated statements. It ensures that recordings used as evidence were made with full knowledge and consent, reducing the risk of entrapment or statements taken out of context. Another question that came up was relevant to when this law was first enacted. And when the wiretap statute was first drafted, the only entities that were envisioned to have the capacity to violate the statute were law enforcement or very sophisticated operational entities. But now with the advent of personal cell phones, recording devices, a recorded conversation can happen without the knowledge of the other party. And it's really just a click away and can be used nearly by everyone, including victims of violent crimes and their perpetrators. So one of the points, I believe it was a professor who made, is that there's studies to show that just having your cell phone out can influence the conversation that's being had. Another unintended consequence, or something that we all know, is that when your cell phone is out, there's all sorts of things in the cell phone that record us. We'll all probably have Google ads later about privacy and different things that come up soliciting us to buy stuff, right? Because we've all been sitting here talking about privacy, and somewhere in the phone, they're now going to sell us something on protecting our privacy. None of us believe that this phone is going to walk itself to court or walk itself to law enforcement and share the information that is within the phone that we've said or about us. Our belief is that in order for law enforcement to get to the contents of their phone, there must be some sort of lawful way that they do that, whether that be by a subpoena or some other powers of the court. And that is a protection that we all relish in, which is that we don't want to walk around just with this now new principle of saying, don't record me, don't record me, don't record me. It takes away from the ability to have honest and real conversations. Additionally, another point that was raised is about the best evidence and recording when things are happening in real time. So let's not forget that if I'm recording something in real time, my testimony is the best evidence because I have observed what happens. I can recollect what happened. I can be subject to one of our fundamental principles of due process, which is the right of confrontation, the right to ask a person what they saw, what they heard, how that took place. Where we're now talking about eliminating two-party consent, I would share that it's not really in the instances of recording an actual act. I will take you to another case in where there was a Uber driver who was charged with raping a passenger who was incapacitated by alcohol. The victim passed out in the back of an Uber that was called to take her home safely. She woke up alone in the back of an Uber. She had no memory of what happened, but she suspected that the offender had sex with her in the car. To confirm her suspicion, she asked the offender for another ride home so that she could confront him and record their conversation. During the recorded conversation, the offender admitted that she was wasted and that they had sex. The offender did not deny that he had sex with her in the car. The DNA could not show, however, that she was incapacitated. The court excluded the recorded conversation under the current law, and at trial the defendant testified that they had sex, that she wasn't that drunk, and that she was not passed out. He said that the victim accused him of rape because he turned her down for a date. His words against her words. So here you have two different versions of where a person goes back in time to record another person without their knowledge to then use that as evidence of what happened or what didn't happen. You have a situation where it's a mother who is seeking to get evidence against her own child to protect the accuser. To protect the perpetrator, and then you have evidence or a scenario where it is the actual victim who is seeking to go back and get evidence in time. And two-party consent in the contents of the criminal space, I would argue, is that this is not just the scenarios where it's recording in real time. What it is encouraging is for whether it be the friend of a accused, a loved one, a family member, you're now in a space where you are almost encouraging people to go back to try and elicit information from the accused to use it against them. So this idea that it is simply going to protect the accused because they can use evidence of conversations where there isn't knowledge by the other person, I encourage you to think of the opposite effect, is where now you have dueling sets of evidence of people who are each using consented to conversations to demonstrate that something did or did not happen. Lastly, the reason why OPD supports two-party consent is that it reduces bad faith prosecutions. I think I covered that it maintains due process and requires transparency and evidence gathering, which aligns with the defendant's constitutional rights to confront witnesses and challenge evidence and authenticity. And reducing bad prosecutions, it deters vindictive recordings, which I just spoke to, made with the intent to harm someone legally, protecting vulnerable populations from harassment through selective recording. So in summary, because I won't go again through all of the points that have all been covered, it is important to consider that our Constitution is rooted in a place to where we seek to have individuals knowledgeable about what to expect, due process, notice, and a hearing, notice being the first one, notice of what is against you, notice of what you are being subject to, and notice of what information is going to be used against you, and in this instance, so that you're not subjected to kind of the gotcha moment of, you didn't know that I was recording. I have no reason to believe that you are law enforcement or that something, for some other reason, that I should be worried about your recording. If we all think about at our dinner table, if we invite somebody into our home now to have a meal with us, do we have to be worried that at that point they may be seeking information from us about, name a topic, that will then be used in a court of law against us? That is not a principle that I think that in the state of Maryland we want to move to. And just because we are in the minority doesn't necessarily mean that we need to move to the majority, where the majority is in a place that doesn't afford protections that the Constitution is truly rooted in. Thank you.
Thank you. Ms. King?
Thank you so much, Madam Chair. Distinguished committee members, my name is Joyce King. I am Chief Counsel at the Frederick County State's Attorney's Office. I'm here representing the Maryland State's Attorneys Association, and I co-chair the Special Victims Committee.
Excuse me, Ms. King, can you just move that microphone?
I'm so loud that I didn't even realize I wasn't on the mic. First, this felt like a law school class, so I just am very grateful. It brought me back. I had a lot of nostalgia. Thank you, Professor Gray. And thank you to Hunter. I regret asking to go last, because at first Hunter's like, when do you want to go? I was like, well, prosecutors usually go last, because I feel like I got to defend our position. But now, having heard everyone, we're really on the same page. And so much of what has been discussed and what the other panelists have said are what all these papers are here. So I will also not just reiterate, and I'll try to just, summarize it. And most importantly, I think when Hunter and I discussed the role of MSA being on this panel is talking about real life cases. Just as a fun fact, and because my interns did a painstaking project for me, I had them pull every piece of legislation and written testimony the last only 5 years on this topic of wiretap. And what I realized, and I felt bad because we killed a lot of trees and they spent a lot of time and effort listening to testimony, is that the testimony has not changed in 5 years in many iterations of these bills. But what has changed is the number of victims that have not had their day in court because this evidence couldn't come forward. And it was honestly really heartbreaking to hear the repeated stories that continued on. Because we haven't intervened yet. And so that I did want to uplift that. And, everybody did such a good job recapping the history, but I do want to emphasize, when the wiretap statute was written in 1956, the inception of it and the basis of it was government intervention. That was a time when law enforcement and governments were physically tapping phones. And there was no foresight of the society and the technology that we have today. But there are a lot of different issues, so I want to stay on task because punishment is one thing, and one party versus two party is another thing. But what I want to focus on is admissibility. Like Delegate Grammer said, and like Professor Gray said, there's a way that we stay two-party, but best evidence can come in, and it's left to this decision of a neutral party, a judge. And this already exists in the residual hearsay exception. The factors that are built into the residual hearsay were copied and pasted into this statute or this new piece of legislation. And I believe these are the safeguards. This is the middle ground where we can move forward. So, and I think it was, thank you to Ms. Morin for describing the landscape of the national layout and how Maryland is an outlier. So I hope that this can be the legislative session that we can do something. So as for the real life cases, so I went to both the SVU subcommittee, but I also went to all the electeds directly throughout for the Maryland States Association to get cases, not just in the SVU space, but in all crimes. Where are the instances that this is happening, and what are the case examples that we're going to see? So I have a long list here. If you could indulge me, I do want to just show some of these examples. First and foremost are obviously where the recording itself is the evidence of the crime. So these are cases of threats to officials, extortion, bribery. Someone calls, says, I'm going to kill you, your spouse, your children, hit record, the recording is captured. Not only has that victim committed a felony, that evidence is not admissible, and there is really, other than their testimony themselves, there's no evidence, right? That recording was the evidence of the crime. And so the perpetrator in that case could take, or has taken to the stand and said, I didn't do it. I didn't say that. And it's then he said, she said, whereas we do have a recording that's not admissible. Obviously, there's the plethora of vulnerable victims, elderly abuse case of family installed cameras. And I think Delegate Grammer highlighted this, suspecting abuse of their elderly mother. Audio captured the insults, the sounds of the slapping, the explicit verbal abuse. And so there was more telling than the video alone. The audio obviously was ruled inadmissible in that case. Multiple domestic violence cases. I'll just highlight one that is very aggressive. So there was an incident where a husband had been released from a 10-year prison sentence, moved back in with his spouse. The victim in that case obviously was aware of the abusive nature, had installed, and the defendant had known at the time that there was an in-home camera. The defendant assaulted the victim by hitting and strangling her. The screams were heard on the audio recording, as well as the sounds of the violence and the furniture being thrown around. Defendant goes into the master room and comes back with what appears to be a firearm, walks back to the master bedroom, and then disconnects the camera. And those recordings were not admitted into court. The most of these cases were rape cases. Calvert County defendant was coming home for a child custody visitation. Because she knew the violent tendencies, the victim turned on the recording function on her phone before he entered the house. Defendant pulled out a gun, forcibly raped her while her 2-year-old was sleeping. She immediately went to the police. For the several next months before trial, the defendant and his family called her a liar, disparaging her, and the prosecutor in that case had to explain to her that although her entire assault and rape was recorded, it was not admissible in trial. In a separate case, you could hear the no and stop during a sexual assault, and again, the recordings were not admitted. There were another firearms assault case. There was a recording, a relative recorded a shooter admitting to the shooting. That admission was not admissible in that firearms assault. An attempted murder case, a mother had recorded a confession of that the defendant held his former partner hostage overnight, intending to kill her, and the confession was excluded at trial. And the last one I have is a child abuse at an in-home daycare. The parents were afraid, had suspicion that the daycare provider had been abusing their child. They had put a recording device on a backpack, and they secretly recorded the daycare provider, in fact, abusing their child. And again, that was not permitted in trial. And not only were they not permitted, that every single one of these individuals did commit a felony. And so that's what's happening in real life around the state. I do want to highlight HB 314 from last year and why we do believe that it is the platform of moving forward is that, hearing what the Madam Public Defender said, I do believe that this remedy, as Professor Gray calls it, is appropriate, that these cases are limited to crimes committed against a person, that the recording is not just to embarrass or to be salacious, that these recordings, it's not to capture your private conversations at the dinner table, it's up to material fact of a crime. So that in itself, and most importantly, it's not at the direction of law enforcement. These aren't controlled calls. We have statutes that navigate those, that this isn't an impediment on the Fourth Amendment. I mean, Professor Gray explained that perfectly, and I think Delegate Cardin brought that up with regards to the United States Supreme Court basis of Fourth Amendment analysis when it comes to private communications. Also note that federal and military law are one-party consent states, so even in concurrent investigations and prosecutions, there are lots of issues in Maryland with our military and federal partners with evidence that is illegal with our state laws, but permissible, and they want to admit them in their military and federal proceedings. And that the judge has to decide, is there more probative, is the recording more probative than any other evidence reasonably available, including one's own testimony. And that it serves in the interest of justice. So I think that leaving this decision, we can maintain the two-party consent law, ensuring the continuation of the values of our own privacy. However, leaving it to a neutral arbiter, a judge, in determining in the interest of justice, in the interest of best evidence, in the interest of public safety and deterrence of these crimes, are we able to move forward in this path? So with that, I'll just leave it open for questions.
Great, thank you. So we're going to move, you all know I always go this way, but I'm going to start this way with Delegate Grammer, Delegate Conaway, Delegate Cardin, and then Embry. And if your light is not on now, we're probably going to end with Embry.
Thank you, Madam Chair. So I think I have two questions. First to the Office of the Public Defender. So you mentioned that the best evidence is actually the testimony. In a lot of these rape cases, we hear, frankly, a conflict of testimony. What if you have a video where you see what you see, but the girl screaming at the top of her lungs, "Please stop"? Isn't that a lot more probative than testimony?
Isn't it a lot more probative than testimony?
Could you speak into the mic, please?
I think it's very difficult, which is the purpose of the law. It is very difficult to answer that question in a vacuum, because the other consideration is that then comes into play is the rule of completeness. Is this a complete video? And I'm just speaking from, if I were defending against this case, things that I would look for. And so if this is not a complete video from the time of the original encounter until the end of the encounter, then what prevents, or is it the best evidence where there's only a portion of the encounter is captured, right? And so I think that to have this idea or belief that a video resolves the entirety of a case.
What if it was 30 minutes of a girl screaming, "Please stop"? You're kind of avoiding the question.
Oh, I apologize. It's not my intention to avoid the question. My intention is to share that the idea of video evidence, sure, there are certain cases that video evidence will absolutely speak to everything that one needs to know. There are also many cases in which video evidence is tampered with, or video evidence is actually not complete. And so again, I think that you're both looking at each other, but I remind you in Baltimore City that it is a prevalent thing that video evidence from law enforcement is tampered with. So I just remind you that to ask a question in a vacuum and then apply it broadly to everyone, I think overlooks that the purpose of the law is not to harm victims. The purpose of the law is to protect all and to apply it in the most fair way possible.
Ms. King, I'd like to give you the other side of that coin. Can you speak specifically to these cases where there tends to be, like what she's arguing is to be able to exclude what is frequently the only evidence. And I want to give you a chance to say, to kind of touch on and elaborate why that might be important, that we have, for me, testimony from a woman who says she got raped and testimony of a woman who got raped for 30 minutes. To me, I'm not an attorney, but that's much more probative. And I want to give you a chance to speak to that.
It is. I'll address it in two ways. One, that the argument that victims can just testify, we know that it is very difficult for domestic violence, for children, of sex abuse, of physical abuse, of human trafficking. There are obstacles, both mental, emotional obstacles of having to testify in court and continuous trauma that happens on these victims. But with all that being said, I mean, yes, do we face recantation or intimidation or other, the trauma leading to lack of remembering what's happening? So yes, do I believe that video of real-time actions, as we have all discussed and seen, quite honestly, in body-worn camera, is the best evidence. But with that being said—
Excuse me, Ms. King?
Yes.
Pause for 1 second.
Well, here we go. There we go. No questions for us.
Okay, Ms. King, sorry for that. You can continue.
Okay. But I will address the completeness because that's a valid argument, and I respect that argument. And that's why we believe that this should be a judicial hearing where these arguments can be put before a judge to make those determinations, as with all evidence.
And the legislation we've worked on, does it provide for that?
Correct.
Thank you.
So I just want to ask a quick question. And I think you probably said it, and I was thinking about the other thing. So there are instances, well, let's just go here so I can be brief. Was your answer, Ms. King, that the whole point of an evidentiary hearing is to hash it out?
Correct.
Okay, great. Well, then that's what I need. Delegate Conaway.
Thank you, Chair. Thank you, Councilman. King, can I get a copy of your file? I don't want you to think that your interns did that all at
I
once.
would love to give you
Yes,
this.
I
I was gonna
okay.
I didn't want to tell them, I was just gonna leave it here.
Oh, you're gonna leave it?
I'm gonna leave it for you.
Thank you very much. Ms. Moran, yes, I have a question. In your example of the mother and child, and this is in reference to law enforcement and child interrogations. Why was the tape not accepted as evidence?
And it wasn't accepted as evidence.
It was?
No, it was not accepted as evidence. Part of the argument was that the mother could consent for the child, and it was deemed that the mother could not give consent, and the child had not given consent, and in a two-party consent state.
The child could not give consent, is that?
No, the child had not given consent to the recording by the
So the
mother.
child could have given consent?
The child would have been the appropriate party to consent to the recording.
Okay. If a person enters into a home where a person is recording their house for burglars and things like that, are they required to tell you that they're recording here and recording video and audio, in your opinion?
Well, I think then you get into, one, I think that there has to be some, and I could be, this is, again, I would have to go and look this up, but.
Okay, you could get back to me.
I can get back to you
Yes.
on that.
Okay. And in reference to the example that was given about the video and someone says no or stop, as I understand it, in Maryland, no means no and stop means stop. So if it doesn't have to be complete, if you see a whole 30 minutes and in the first minute they say no, stop, I've changed my mind, I don't want to do this anymore, and you say, oh no, it's too late, I believe that's statutory rape.
And I believe that your example actually draws on an interesting point, which is that two people have to consent in order for it not to be rape, right?
No,
Two people.
no, that's not what I said. That's not what you said. You said that you didn't see the complete tape.
Correct.
Right?
Correct.
Not what happened before the tape, not what happened after the tape, but during the tape, this person said, stop. Right?
Correct.
So they consented in the beginning, but when a person says no and stop, as I understand it, no means no.
Correct.
Okay, so I don't want to send the wrong information to the people in the state of Maryland. No means no and stop means stop.
Correct. Okay. And I think that the answer I was giving is that the reason why we value that a person can consent and then change their mind and withdraw consent is because we value the idea that when two parties engage in anything, both of those parties have to give consent and with knowledge of what they are entering into. Where we move to a place of one-party consent, we are taking away that principle from one of the two parties who are being recorded.
Okay, thank you for your answer.
I'm going to move on to Delegate Cardin next, please.
Thank you, Madam Chair. Thank you guys very much for coming and testifying. And it seems to me that, Ms. King, you're talking about a relatively narrow exception that you have tried to advocate for over the past few years that you're going to continue to advocate for. And it seems to me that the two of you are kind of on board that you're okay with that exception because that would not necessarily be a problem on the examples that you gave from the Public Defender's Office. Is that true?
That is not true.
Is not true?
No.
Okay. All right. Then I'm not going to ask how it's not true because I'll figure that out later. But my question is more about the creep of exceptions to move us from where this is just sort of a narrow carve out to we're essentially becoming a one-party state with a few exceptions in two-party. And I'm wondering if maybe Ms. King, you can allay my concerns that that's not in fact the case.
I don't even like utilizing the word exceptions, because what I like to call this is an evidentiary rule remedy, like Professor Gray called it, because it's not a carve out. We tried many iterations of bills carving out that it doesn't apply here, it doesn't apply here, it doesn't apply here, which are chipping away at the two-party consent. This is a broader stroke. It is an evidentiary ruling, and it applies to all persons crimes. So it's not just SVU or, victims. It's any person's crime, which is anything that would really be engaging while you would be recording someone, is you feel like you are being harmed or something, that's why people take out their phones, because something is being encroached upon. So I think that hopefully that assuages your worries or concerns that this is, some sort of Trojan horse to move into a one-party consent. I think that this puts real safeguards to protect the privacies of our citizens, but leaves discretion to the court that in the best interest of justice, and residual hearsay that utilizes the same principles is not used every day, and I think we can agree as that as counsel. I mean, these are very limited cases of which it rises to the occasion of
So let me give you an example that perhaps my colleague from Baltimore County is not here anymore. But let's just say, to the sake of argument, that a judge finds that racial discrimination against a minority in housing is tantamount to serious harm that could cause somebody some serious damage to them or to their family or some way. So therefore, this public safety exception should be used for somebody to be able to record a landlord and a tenant having a conversation about the cost of rent.
With regards to the fair housing legislation, I don't believe that's applicable in this bill. The way that it was drafted, it applies to crimes against a person. And whether that's my misunderstanding, I'm looking back at Lisa Jordan, if I'm misunderstanding that, but it would not apply or be applicable in those types of cases.
But could a judge make a decision that it should be broadly sort of understood or not?
I said yes. I took privilege because I have a bill that says exactly that.
Okay, thanks. Thank you.
No, but in all seriousness, I was just making a joke there, but we'll see. We'll see if that happens, right? Delegate Embry?
Thank you, and thank you all so much. And forgive me because I did step out, and I apologize if this was covered. I don't think so, though. And part of it is following up. I actually don't think this is limited to crimes against persons, but I may be wrong. And I'm looking at 314 from last year. Oh, okay. So it would be.
Yeah.
But so I am supportive very much of this evidentiary exception. But I am concerned because it leaves the person, the victim, open, of course, to both criminal prosecution and civil liability, and I don't know what the answer is in terms of a compromise. But I assume you would offer immunity from criminal prosecution if you were going forward. But I just didn't know if you or the sponsor had thought about if there's any way to build in a protection for civil liability, if that's been considered.
Yes, for every case and every case example that I've given, the state's attorney's office has given immunity for those individuals. And with regards to penalty, the MSAA for the last 5 years has supported the moving it from a felony to a misdemeanor, and every year. So we would be supportive of any type of legislation that way.
Great. And Delegate Tolles.
Thank you so much, Madam Chair. One quick question to the Public Defender's Office. It was kind of silly, but you did say that people can walk around and kind of say, "Don't record me," right? Remember the comment in the beginning?
Yes.
And so we know in court that obviously one of the main pieces of evidence are photos. So I'm just curious to know, because my team jokes with me, but I tell them I do not consent to taking this picture if I'm not having a good hair day or something like that. And they would tell you, I tell them to take it down off the website. I do. I said I do not consent to this photo. So you taking pictures of me. With, you know, if two-party consent was to pass, how do you think that will play out? Because I do think you bring up an interesting, you know, point that folks may walk around and say, don't record me, because you know, folks do that with photos, but obviously it's used in court all the time because we have cameras everywhere. So what is your thoughts on that?
I'm sorry, what are my thoughts on the?
I mean, just, you know, to your point, is that something that, do you feel it will be really problematic that folks really do have to walk around and say, don't record me, don't record me, don't record me?
I do think that it creates a problem, and I do think that it creates a larger problem. We say it in jest now, but in reality, it's a possibility. In addition to that, why I think that, or why we would argue that it is a problem to consider is that where you now, so don't record me, for individuals that learn of this exception, what prevents them from going and recording a person or eliciting this type of, in their mind, you know, mitigating evidence from a victim or even from the accused? And there isn't anything. And I think that it is really easy for us, or our ability to apply this to the most egregious of crimes, to rape, to, you know, violent sexual offenses. It's clear. But this idea extends beyond, even if with the bill and its limitations, this idea that the bill builds into it some sort of protection to where it eliminates people from going and doing what the Uber driver did, which is to try to entrap the accuser the perpetrator. That is something that we should be concerned with, because where we see it in this example, and it may be easy for us to believe that this should have been allowed into evidence, this clear-cut notion of this is how this works and a judge can hash it out is not how it plays out in the actual practice. And so I do believe that you're going to end up in a space where people are now walking around saying, don't record me, or adding precautions to take themselves out of this type of evidence being used against them.
Okay, thank you.
Thank you. Okay, I have a question. I think this is probably for Ms. King. And currently, are text messages allowed as evidence in an evidentiary hearing?
Yes.
Okay. And then my other question is, without consent from one party or the other?
Yes.
Okay. So my other question is for Claire, actually. Did you know that the first cell phone was invented around 1973? And didn't you say that the law changed in 1973 or something of that sort? Wasn't there an act? Is that the title?
77 was the amendment.
It was 77? Oh, I thought I saw 73 somewhere. Okay, I didn't know if that had any correlation. That was going to be my question, if there was anything in your research that found any correlation with the invention of the cell phone. This is all stuff we can talk about later. It's not that important. Thank you. Okay, and it looks like that ended all our questions, which is great. I think this was a good discussion. I think it was a great briefing. I think these are things that we needed to talk about, especially given the big binder that Ms. King has, and obviously the bills have been introduced. Yeah, obviously the bills have been introduced several times, so we need to, have this type of discussion. I thank our chair for setting this up, and I thank Hunter for setting it up as well. With that said, if motion to adjourn, we have no further questions. This ends the hearing of the two-party consent. or the briefing of two-party consent.
Great job.